also issues and the problems within the construction period and even during the design process. So the question is whether design and build would be better. One, I'd say that it would bring streamlined communication, ensuring that things would flow much better. And in that, of course, you have early collaboration and communication between the various parties. You also in the design and build, and everyone would be on the same page, so that even during the times of design and the initiation of the project, that you have the architect, the consultants, all of them together, and of course with the contractor being involved, and therefore there is a possibility of issues being solved much more quickly in that level. It also reduced misunderstandings because the contractor was there from the beginning and he knew what was going to happen. The second one is the issue of single point of responsibility, meaning that design and build contracts, the responsibility basically focuses on usually the contractor who has put everybody else together. So you avoid finger pointing between the consultants, the designers, and the contractor, and even the client, because even the client would be involved. So there's a clear point of accountability for the entire project, which is not possible in the traditional method. There's also efficiency and cost savings. The quantity surveyor is involved. Everybody is discussing. The contractor might say, I have a better way of getting these materials, probably cheaper. He might bring other options because he's involved from the word go. I'm sure we shall discuss, therefore I do not want to go into too much details, but there is also flexibility and of innovation, because during this collaborative ideas, the models that are coming out in the whole process, you'll find that everybody is involved, and therefore there is a way that everything is being discussed. So you foster innovation and creativity in problem solving, because when an architect, a contractor looks at the architect's design, and even the engineering design, he may come up with new ideas, which of course the group would be quite ready to take. Then of course, design and contractors working together brings the best solutions in the project. So this is a little bit unlike the traditional method, where you get those in a different way. This can lead to more tailored and high quality outcomes. Finally, on this sector, I also talk about risk management, because by engineering a single entity for both design and construction, you are avoiding risks, because you discuss all those cities and come with a better solution. Secondly, a client can benefit from improved risk management processes, because he gets to understand what are the risks, what are the issues, and therefore he can also address some of those. Then thirdly, contractors can provide valuable information during the design phase. Information that may be obtained during this design phase, which the traditional method doesn't have, is that when not everybody is together, contractor is involved, and everybody else, you are likely to reduce the likelihood of problems and disputes. Now, we go to the next sector in this area, which is what are the most common, the question is, what are the most common design-related causes of time or time-related claims encountered, and how can design team better collaborate on these? Some of the most common design-related issues, I'm talking about the you find that that you may end up with misunderstandings of various kinds. But when people are together, when you are designing together in the design and build method, there is encouragement of early collaboration between the design team, the contractor, and also the employer, the client, who is the owner of the building. Project goals, requirements, and timelines are clearly set up, and therefore you find that there are no big issues with regards to those. At least they are discussed and understood, and where changes need to be done, they can be made. There is regular meetings and open communication channels, identifying potential issues and potential problems. So you can map up the whole progress together.
Moses. You're good?
Hello?
Okay.
Then regular meeting and open communication channels, identifying potential problems, and these can be addressed together. Then there is a clear design scope. With regards to the clear design scope, we ensure that the design scope is well defined in the design and build method. It also avoids ambiguities, inconsistencies, and all the design documentation is done properly. Everybody understands what is being dealt with. Then thirdly, timely design reviews. Because of being together, one is the consultants and the group is able to establish clear timelines for design reviews and also the timelines for various activities, preventing delays in construction, which of course would lead to disputes. You also encourage timely feedback from contractors, design documentation, and everything else like that. It makes everything easier. Then number four, change of management processes. When during the construction, during the whole of this design process, if there are issues, you can, and you find that there are changes which have to be implemented, it is easier when they are all handled together, rather than one party hearing later, oh, there was a change, we made a change here, we went 2 floors deeper and so on, when it is already late. Everybody is involved, everybody knows what is happening at the same time. There is clearly defined procedures for documenting revisions and reviews and so on. So there's a clear line of how things have been happening. Finally, on that section, approving changes of design, minimizing the impact of delays or any other thing of that kind. Then construction reviews also, conducting constructability reviews with the input from both design team and the contractor. You identify potential construction challenges early in the design phases. You also optimize on the design and efficient construction and reduce the likelihood of disputes. Finally here, I also consider the risk management. Again, there's a collaboration at risk management, assessment, mitigation strategies can be implemented. You can also address design-related risks that could impact the project schedule. You're also able to proactively identify and manage risks, which can help delays, prevent delays, and eventually, of course, avoid disputes. Finally, on the third issue, the third question is, it says that when unforeseen site conditions necessitate design changes, how can architects balance contractual obligations, ethics, duties, and practical realities to avoid project derailment? Now, obviously, we all know as consultants that changes come very frequently.
Hello, sorry, architect, we are getting the flow and we are liking it, but there's somebody's conversation that's leaking into the main forum. If you could please check your microphones and mute if you're not the speaker. Thank you.
Those are not from my side, unfortunately, or fortunately.
It's I am hearing from your side, architect. Yeah, back to you, Askibati. Sorry, you're muted, architect.
Okay. Yes, I was. Sorry for that. I don't know how it happened, but on the unforeseen site conditions which necessitate design changes, this is very common. You design something, assuming that the site is as given to you by the owner of the building, and so on and so forth. And then when you go to site, you find there are a lot of problems. The site is not even flat, it's slopey. You need basement, which you didn't think about. You need other considerations, and probably you even find issues like a quarry, which is on the site you didn't know about. But these unforeseen conditions can make everything very, very difficult. And so I'm looking at this area and assessing and trying to find out what are the practical ways of dealing with it. First of all, there is assessing the situation. architects promptly should assess all these unforeseen site conditions by being ready for them. Their impact on the project design schedule and the budget can confuse everything. Then one needs to understand the extent of the changes, making information and decisions early enough so that it is possible. Obviously, this is something which causes a lot of problems, and it also comes quite often in disputes between contractors and the project developers. Because the information wasn't known and the architect designed without knowing exactly what was happening. So it is necessary to communicate effectively. Open and transparent communication is necessary with all stakeholders, clearly explaining the reasons for the design changes, if there are, and try to avoid them, and the implications for the project and any associated risk. This must be understood. Then review contractual obligations. Architects should review the project contract obligations and respond effectively to any unforeseen site conditions and problems which may come. Because if you don't let your client know that these things are going to cost money, you might find that the project would stall and you end up in an arbitrator's office. Then also is the compliance with contractual terms, essentially maintaining all the project integrity and upholding professional standards. Because sometimes you get those changes and you apply quick solutions without really checking everything. So it is necessary to comply with all contractual terms. Then there is also ethical considerations, upholding ethical standards to prioritize health, safety, and environmental concerns, and also design changes complying with applicable building codes and building standards, because you do not want to avoid these simply because there are some changes. Architects act in the best interest of the clients, maintaining professional integrity and being completely ethical. Number 5, it is necessary to collaborate with stakeholders at all times. Work collaboratively with contractors, with all other stakeholders, addressing all the unforeseen conditions which may now have become evident, engaging in constructive dialogue and seeking to input from diverse perspectives, considering also solutions, even trying to find out whether it is necessary to make a lot of changes. Then document of all the changes is necessary. I say here 4 items: comprehensive documentation of design changes on the site conditions. We take photographs, make sure that everything is clearly understood and why the changes became necessary, and you have clearly recorded in minutes, even letters, of what is happening. Decision-making process is crucial. Keep detailed records of all communications, revisions, and approval of, which to mitigate potential disputes and ensure the project is finished in a timely manner. Finally, on all these sections, I have talked about risk management, and I am saying here that you must again evaluate the risks associated with these changes. Costs will become higher, project will take longer, the planning of the project which was done at the beginning may no longer hold. So the second one is implement risk management strategies and mitigate their impact on the overall project. Then consider the practical realities of construction, because when you do these changes, there is a possibility that even the contractor has to change his strategies so that he does things in a more applicable and better manner. Then, of course, budget constraints and project timelines when proposing design solution. I don't want to say anything more. I think I've finished the 3 sections as requested, and I wish to stop here so that a further discussion can be held during the Q&A. Thank you very much.
I appreciate your remarks, Architect Stanley. At a later phase, we'll probably look and inquire as to what hinders us from adopting collaborative working models such as the design and build. For example, like poor communication as was seen as early as the time of the Bible, that Tower of Babel, as seen from the get-go. So we probably should consider working together more in a bid to hinder this. We will next have QS Cairo talking to us about design analysis. You are invited, QS.
Thank you very much, moderator. Can you hear me?
Yes, we can.
Thank you very much. First, I'd like to say that it's very exciting, at least for me, noting that this webinar has got close to 150 participants. It's a rare occasion for one to get an opportunity to address such a large team of professionals. It's my great honor. Thank you very much. Now, coming to a few housekeeping issues. First, I'm not used to talking to blank screens. I find that this connection is lacking. I was hearing a very good presentation from my colleague, Architect Kibadi, but it's a pity that I could not see his face.
Control room.
I like appreciating the body language when someone is talking. So I don't know whether it's possible when people are speaking, asking questions or presenting, we can have our videos on. Now, point number two, third point, when I got the program,
they give you this.
the program, I thought we had
that bag here.
Hi. Sorry, there's somebody's conversation that's interrupting ours. I'm so sorry, QS.
Yes, I'm
Kindly check
hearing.
on your mic. Somebody probably put on their video and mic simultaneously.
For me, my video is on. I hope you can see me.
We can see
I was
you.
saying
We can
that
hear you well.
for the, I thought the program was in two parts. The first one was for the opening remarks. Then we go for the questions that the panelists are supposed to be tackling. But I noted that my colleague wrapped up section 2 and section 3 together. I don't know whether I should do the same or just follow the program. Sorry? I am saying, I don't know whether I should first start with opening remarks.
You can do the opening remarks first. The program remains as well. Hello. I don't know if I'm the only one not hearing QS Cairo. Oh, you're muted, QS.
You muted me. Is it okay now?
No, it's fine.
It must have been automatic unmuted. Now,
Yeah, but in via.
I am saying that in making my opening remarks, I would like to make them in the context of the title of the webinar, which is Design, Delay, and Disputes. And then you see managing time-related claims in construction. It is in that context that I want to do this delay analysis, in that particular context in my opening remarks. First, I'd like to say that all these issues regarding delay and claims are actually a creature of the contract. They are contractual issues that are actually managed or governed by the contract between two parties, usually the employer and the contract on one side. Ordinarily, those are the two parties to a contract. But as you all know, employers don't directly take an active role in the management of the project. They do so through their agents. And these agents ordinarily would be the architect, QS, engineer, all the consultants, including services engineer, These are agents of the employer, and they are the ones who interact on a day-to-day basis with the contractor. Then, of course, the contractor would have his team. So when you talk about delay and delay analysis, again, you also have to look at what stage of the project are we talking about. There is a design stage, and remember, design stage ordinarily takes place before the contracts are signed. So in the context or in the understanding of a delay, I do not see how a delay that happens during design can actually lead to a claim from a contractor. Contractors' obligations, rather rights and obligations, kick in after the contract has been signed. And unless it is a different type of contract, which is actually like Kibadi alluded to, design and build, where the time kicks in from the time that a contractor is told, okay, you're doing the design and you're doing the construction, sometimes even funding. That the delays can only start kicking in after the contract has been signed, because that is the time when the parameters, performance parameters, in terms of finance and time, have been set. And when you talk about delay, time-related claims, you can only be looking at them in the context of the time that the contractor promised or contracted to perform a project. Now, again, just in your opening remarks, if you look at analysis of these delays, who causes these delays? And I'm actually discussing post-contract delays, assuming that the design has been complete and the contractor is told now the scope of the work is relatively clear. Even if it is a contract based on drawing and specifications, in this particular case, design will be assumed to be the completion of the drawings that will form the basis of the contract before the construction starts. But of course, we all know that rarely is it possible to have 100% completion of design before construction starts. So ordinarily, you'll find that whereas most of the design is done pre-contract signing, there is still some design, some form of design in terms of modifications, additions, omissions that takes place once a contract has started. And these are the ones that can actually have an impact on this thing we are calling delay, because I'm discussing not design analysis, but delay analysis. Now, again, so the people who are actually can be responsible for causing this delay. You see, there is the human interface. Basically, a contractor can cause a delay by not being able to employ enough resources to discharge his or her responsibility. On the other hand, the employer, either really directly, but through the agents, can cause a delay by not giving the required information in a timely manner. So if, for example, you look at all the contracts, and have in mind, for example, the standard form of contract that we are all very familiar with, starting with the JBCC contract, which is used in the building industry. Then you go to contracts like FIDIC. Then there is a government contract. All these contracts are very, very clear in terms of definitions as to what the contract period is. They clearly define when it will start and when it will end. These contracts clearly define who will manage what aspect of the project. For example, in the JBCC contract, the architect is the one who is squarely responsible in issuing instructions. Of course, these instructions can be also issued by an engineer, or services or structural civil will be deemed to be working to be doing it on behalf of the architect, because the architect is one named administrator. Then, of course, in the same contracts, we have the responsibilities, say, for the QS to do work in a timely manner, or an engineer. Then, of course, the contractor has his own responsibilities that shall provide information. If it's, for example, they require certain instruction, they have to ask for this information in a manner that is defined in the contract. So you find that this delay analysis actually has to take into account what is the cause of the delay. Then, of course, we know that, yes, we are looking at delay, time-related delays, and claims. There are two types of claims generally. There would be a claim for an extension of time without money compensation. You know, for example, if there is a delay that has been caused by an act of God, or what we ordinarily refer to as, what we usually refer to as force majeure, the contractor would be entitled to an extension of time. So they'll be putting a claim for an extension of time, but that claim will not come with compensation for money. Then, of course, there are other, say, delays that can be caused by the contractor, yeah? And when a contractor causes a delay, it's a time-related delay. The same contractor cannot make a claim for compensation, but the employer can indeed make a claim for compensation. And the contractor's claim for compensation, when there is a delay caused by the contractor, ordinarily comes in form of liquidated and ascertained damages. That seems to be the claim that the contractor can make. You promised to deliver my contract this particular time. There have been delays which have been certified by either the engineer or the architect, who have been caused by you, the contractor. You will therefore, in accordance with the contract, compensate me or pay me L&A damages of particular amount. On the other hand, if a delay is caused by the employer, and remember I said that employers hardly cause these delays directly. The delays caused by employer would in most instances be a delay caused by the consultants. For example, if, say, the architect or engineer did not give information in a timely manner, and this information causes a delay in the time of completion of the work, in that particular case, the contractor will be entitled to a claim, yeah, for time, extension of time, as well as money loss, because you see there are consequences. So we have to look at that and see what kind of delay are we talking about, is the cause of the delay. So I think in terms of, and you can see actually that these delays, more often than not, are actually caused by the people managing the contract. Obviously, the employer can cause a delay. Say, if, for example, they decide that I would like to remodel my building, and the contract has already been signed, obviously, you see, the contractor would have to be compensated for the time that it will take to do that remodeling. And of course, indeed, the extra amount of resources that the contractor will be required to deploy to be able to achieve what has been redesigned. But more often than not, most of the people who interact with the contractor are actually the consultants who act as agents of the employer. But also, remember, in so much as these consultants are supposed to act as agents of the employer, they are actually professionals, and they are also required to act in a partisan manner. And therein lies the biggest issue sometimes, which you can see in claims, where, say, consultants have not acted in a partisan manner. They have probably been the cause of the delay, But the same consultants are the ones in the forefront of trying to argue that the contractor cannot put a claim for this and this and this. So you find these conflicts do arise. I'm trying not to be academic, but to be very, very practical, because this is what happens in the industry. Incidentally, when you are reading my credentials, I must say you used an extremely old CV, but it's okay. It's not about CVs. I'm no longer the chairman of JBCC. I used to be many years ago. So that is not part of my credentials. I am a very active ADR practitioner, and I'm active in mediations, adjudication, arbitration. So what I'm actually saying now is the experience I've drawn when I look at the sources of disputes in relation to delays caused in a project. I think for now, I'll stop there. Those were the opening remarks, and at the appropriate time, I will respond directly to questions 1, 2, and 3. If it is in order, moderator.
It is well in order. Apologies for using an outdated version of your reach all the same, and you gained a lot. I was nodding very hard when you got to that acting in a partisan manner when it comes to consultants. Yes, you are on the employer side, but yeah, fairness applies. So thank you for those remarks. Now we go to our chair, CIArb Kenya, Prof. Kenneth Mutoma. You are welcome to give your remarks.
Yeah, thank you very much. I've also learned a few things about my very good friends who are on the platform, including QS Cairo. I did not know that he was the chair of the boxing association. That is another skill. I know he was an arbitrator and a QS, but I didn't know that other side. Now, I'm not sure how to approach it because both my predecessors have sort of dissected their presentations in 1 and 2. Madam Moderator, I'm wondering whether we are at liberty to take either option. If that is the case, then I would probably, because I know Architect Kibathi will not have another round, I would probably, for equality in the playing field, ask QS Cairo to then go on and complete so that I can then come mfululizo, because I suspect that I'll want to do that towards the end. If that is with your kind permission, Madam Moderator, that may assist. And in that way, I can glean on what my good seniors and predecessors are saying and give the eyes from a dispute resolver. There are a lot of good things that have already emerged, and we can talk about them from the perspective of a dispute board or an arbitration tribunal.
If you can, Prof, you can probably do your opening remarks, and then we'll come and look at the 3 questions at the second session, which is the discussion questions. And I'm sure our audience has questions. So Kibathi will answer those follow-up questions regarding the section he just touched on. So our audience is invited to put in their questions. Yes, we will not lack material to talk about. You're welcome, Prof.
Okay, very, very well. That is fine. I like the approach that my good colleagues have taken prior, which is conversational, to keep this very practical. My opening remarks, of course, is to introduce myself from a multidisciplinary context, both in the world of the built environment as a member of AAK, in the world of CIArb, as an arbitrator and adjudicator and mediator, and also in the nature of counsel as an advocate. And we do have quite a few of the fraternity present. I think I had seen the Africa trustee who has joined us. Very privileged to have him join us all the way from out of the country. Now, putting on that lens, one is that all of this and everything that we've had so far is going to end up in the before a dispute is over. Everything. So whether you're talking about the nature of the contract, its interpretation, its execution, and even aspects post its execution. Somebody must deal with those issues, and that's where the dispute is over comes in. That means, like any good game where you need a great result, and a great result is not necessarily the one that you win, you need a very good referee. If you don't have a good referee, I'm not sure whether there are any Liverpool supporters on this platform, but thank you very much. At least moderator, Architect Wanza, I'm not alone. You will watch the dismal games by one referee known as Ed, like I forget his second name, where either the person is clueless on the rules of the game, and or directly biased on the outcome that they want to achieve. So both of them could work. CIArb therefore thinks very critically about the quality of the dispute resolvers. Again, in my introductory remarks, I think, and later on I will hammer on this point, one must understand the context in which all of this is happening. You can see the context is quite rich. It has several players, tripartite in most cases, the employer, the contractor, a range of consultants that act as agents, and you could see the dilemma. One time they're agents, tomorrow they may be actually called to offer testimony as witnesses before the tribunal. At the same time, while they are agents of the employer, they're also called to be impartial within the context of their professional ethics and integrity. So they're meant, the architect is not meant to favor the employer in the role that he plays, and the engineer and the QS and so forth. But understanding the rules of the game means not just knowing the players that are inside it, but even the person that's going to make decisions must have the technical competence to know and to separate the wheat from chaff, as they say. Now, construction disputes relate, as you heard from CIArb, that a lot of it emanates from the contract between the parties. Those contracts, first, are very detailed in many, many instances. Second, they assume the norms of industry, both local, as you heard with the JBC, and also international, as you heard with the different FIDIC contractual forms. I think there are about 7 or so contractual forms, each of them dealing with very unique aspects. I think Architect Stanley Kibale started off with much of the content relating to the Red Book, where it's very traditional, the employer providing the design through their agents, the engineer administering the contract and so forth. But as you can see, there are other forms in which this can happen. The Silver Book, where you're looking at a significant passing of risk to the contractor who deals with design, deals with time, deals with cost. There's no engineer and so forth. Somewhere in between, you'll find the yellow book, more in keeping with what Architect Stanley was saying, design and then build. And then the other shorter versions, like the green book. And there are also other versions that deal with specific subject matter. Those that are looking specifically at consultant services, like the white book, and those that look at the area of marine infrastructure, marine construction, like the blue book. Each of these have different forms. I just wanted to talk about this a bit, so to show you that there is a considerable learning curve that players in this world have gone through. And so some of these forms, are constantly revised because of lessons acquired. The earliest being in the 50s, I think the Red Book somewhere in the 50s. And the most latest, the second, rather the latest editions being as recent as 2017. Why am I saying all of that? Because there is a presumption that whoever adjudicates or resolves this dispute must have a certain level of expertise to be able to understand what essentially is a contractual matrix and many of the key aspects that my colleagues were speaking about on how the contract is administered and how risk is allocated. From a CIArb perspective, I can say without any reservation, this is why this webinar is very, very key, Madam Moderator. We would want to see at the center of that dispute resolution process more and more members of the built environment, because they have very little to catch up on since they know the terrain and they are best versed then to understand a dispute that has unfolded inside that terrain. Unfortunately, I think we have much more work to do for various reasons, because and I think here Architect Kibathe will agree, our primary learning at the university and tertiary levels gives a very strong impression that your career only assumes one form. And so the idea of architects being dispute resolvers, QSs, engineers, and so forth doesn't really sink and probably what's the word? The clause don't enter. I'm not sure how many people moderator could say that they are arbitrators on this platform. So that, I think, is a very, very key message for us now speaking as an institution and in terms of my opening remarks. In the context, the very specific context of delay and delay analysis, they are, I will make 2 or 3 points, and they will reinforce what my previous predecessors have said. One, that that delay can be the result of various stages of the relationship, the contractual relationship. One, at the very onset, it could be related to aspects within the design process and how they are communicated from one party to the other. So as a dispute resolver, you will always see that. 2, it could relate to aspects within the contract and its implementation. And here we are speaking about the question of variations, and I think many other instructions that would change the direction and the scope in which the project was conceptualized. Two, within that within that implementation, it could also arise from how risks are treated, including potential disputes. And here, this is why dispute avoidance and adjudication boards, and particularly the standing DABs, have become very popular, because of the offering that they present on how to see those disputes as they come and how to resolve them before they become a major hindrance in the overall timelines, the critical path, and so forth that have been conceived in the project. And then last but not least, all of this within the eyes or the lenses of QS Batch's comments on liquidated damages and loss of profits and so forth, they all have something to do with whether what was envisaged as the completion date actually stays the course, and whether any of those disruptions then will either take the project beyond that finishing line and lead to some form of liability between either or all of the parties. So that is until that stage. There are, of course, other forms of delay related analysis that's pegged to my last comments on the completion date, including how questions of latent defects are handled, because those timelines are directly related to when a project completes, or whether there have been extension of times that have been granted to change that line of completion. Now, what is very interesting, and maybe this is my parting shot at this stage, is about the project beyond its material life. Delays can also arise, and in a very costly manner, because of the dispute resolution process post. But now this is a big debate and conversation. And remember, time always translates to money. And so we are seeing a lot of that. And the reasons for that, I think we can have a very good discussion after this. The mechanisms that were originally envisaged were set in play by the construction industry to deal with the question of delays and disputes. Has that promise still yielded fruit today? And if it doesn't, what can we do about it? So in a very layman's language, when you get into an arbitration tribunal, what is the amount of time that you will take before that matter is successfully concluded? And contrast that with other forms of dispute resolution. When you go before a dispute adjudication board, what are the timelines that kick? And are those mechanisms final? Or do we find ourselves right back to where we started, and the courts step in? And you know what it is when we start talking about the courts. All the problems associated now with the formal litigation come in an industry that cannot, for very, very unique reasons, subject itself to delays. It's very, very costly, and so forth. So thank you very much, Madam Moderator. Let me hand over back to you. That is my opening remarks on this topic. Asante sana.
Thank you, Prof. Chair. Your opening remarks are a perfect segue to our next session. I wish you would dwell there. And also your emphasis on training. Now that we have the technical background that is in construction, it is good to also have the dispute resolution one. That way we are able to, yes, you're not appointed as the dispute avoidance board, but just as a consultant in the built environment and with a background in dispute resolutions, I find it really helps in avoiding disputes before we get even to bigger problems. And it's good you also mentioned that we have a mixed audience. So if you would kindly just tell us what your practice area is, whether we are talking to people in the built environment, people in dispute resolution, or both, just let us know in the comments, as well as your questions. We will be taking them in a few. Just to go back to Prof before, because we touched on delays when it comes to dispute resolution, I'd like you to handle for us whether, considering the changes posed by concurrent delays in Kenyan construction projects, do Kenyan arbitral tribunals and courts offer clear guidance and consistent frameworks to promote fair outcomes? You also talked about fairness. Or is there a tendency to opt for compromise resolutions, that's splitting the difference, rather than undertaking through substantive analysis of each party's liability? If you could please.
Okay, thank you very much, Moderator. Maybe to preface that discussion and what would happen in ordinary circumstances, I think it's important to paint a picture of what or how that all unfolds when you're dealing with the questions around concurrent delays. The first, of course, is unfortunately, many contracts will reveal a serious power imbalance. The power imbalance will manifest in so many ways, in resources that one party has available to it and vis-a-vis the other party. The power imbalance is also going to manifest in terms of skills and awareness. And it all depends on who is on the table in that contract. In a lot of the smaller contracts, you might find the power imbalance in favor of the contractor. In a lot of large multi and transnational contracts, you might find it's in favor of the employer as an investor. This power balance ultimately translates to risk allocation because as the parties contract, one has more weight to insist that certain risks sit on this side vis-a-vis the other side. Of course, standard terms such as in FIDIC and JBC and so forth have, in a great measure, enabled us to standardize that. But unfortunately, we will have contractual standard terms and they can be varied. And it is quite often that they are varied. They are varied when it comes to certain prescribed forms, notice periods, mechanisms in which those notices are communicated, the dispute resolution related sections, and how that is conceptualized. So that, I think, Architect Wanza is the starting point. So you will get served a dish that already has been prepared in a particular way, and you then must, as I say, work with the way it has been molded. and you'll work with it to try and achieve a fair resolution, and a resolution that illustrates your expertise on the subject, that you understand the unique context of that dispute, the position of the parties in reaching a specific outcome. I won't hammer on this because I think the two tend to go hand in hand. You can only adjudicate to the extent that you have competence or capability. I think if you don't have that, you will end up spoiling the food that, if you allow that analogy, that's been served, and even making the dish much worse. Now, in light of your question, and I think this is where the problem starts, when you're talking about concurrent delays, the tribunal sits, of course, with this mindset that it must deliver efficiency and expediency. But as you correctly pointed out, it has then to wade through a fog, this fog of where two parties are all suggesting that delay was occasioned by either of them. And when you had QS Cairo Bache's presentation, you could see how that would arise, even with the employer through the agency of architects, QSs, and so forth. Either design variations that were expected are not delivered within the timelines that were anticipated, or where the contract permits products were not supplied by the employer as expected. You can add to that layer so many other layers that cause even greater ambiguity, because some of the disputes that have come to us show the delays arising out of change of laws within the world of supply chain, transactions, materials that are coming from China, particularly in the COVID period, something that has happened. Had envisaged implementation. Now that is compounded, on the other hand, by some kind of contribution also with the employer, with the contractor on the other end. Architect Stanley was talking about communication, and we also have another layer that we repeatedly emphasize: records. And different parties are responsible for records, and you find that that has not happened. And that, alongside another mix of issues, such as the quality of performance, now prevents a very, very dicey situation to a tribunal when you're trying to apportion who exactly is responsible for a delay. Sometimes it gets so complex, and unfortunately, where you don't have the expertise, we are seeing what you call the compromise conundrum, that just finding a way to split capability and liability between the parties. But that has serious flaws in it, because for one, it doesn't have the empirical support. And it is clear that it is sort of a an attempt at an equitable apportionment between the parties. And it is very, very dangerous because in the long term, it sort of raises doubt and questions over now the parties' responsibility during the contract and whether they are being actually rewarded or they are being punished for that. So when you look at this tendency to compromise, without a very strong supporting evidence, while it's good, maybe from the perspective of commercial relationships and so forth, and maybe it is a way out for a tribunal trying to wade through the difficulty of precise liability, it has other implications because it inadvertently disincentivizes the party who start this relationship with the idea that if I keep thorough documentation, then I'll have supporting analysis if I end up in a situation where that analysis will now form a part of a delay claim. So that, I think, is very, very key to mention. I could go on. I'm not sure whether I can go on that aspect because I was going to probably suggest one or two things on how FIDIC forms may assist through their standardization. But Madam Moderator, allow me to stop and yield the floor to my colleagues. Asante sana.
Okay. Thank you very much, Pro. It is abundantly apparent from what you said that the ability to deliver a project is largely dependent on the quality of a contract first the parties have entered into, and then how they document their project. So I'd like to ask QS Cairo whether informal fixes for site delay, we can later formal claims, okay, sort of a leading question, and should quantity surveyors push for stricter procedures?
Okay, thank you very much, moderator, for that question. But maybe before I come to it, let me just ride on what my friend Professor Wine has spoken about. Because remember, we said you're asking me from my experience. He spoke about a very interesting concept of power imbalance with regard to risk allocation. Whereas this is a very good concept for us to appreciate, we must understand that once parties have executed a contract, then a dispute arises, the tribunal or the court for that matter, be it arbitration or the court, would have no jurisdiction to try to rewrite what the parties had already agreed in the contract. So it's a pity, and I know this happens, particularly when contractors are very desperate to get contracts. They don't take time to question or negotiate certain clauses that will minimize their risk exposure. They just go ahead and sign. However, you see, it is in the interpretation of the various ones that dispute arises. It is in the interpretation of various contractual clauses that an arbitrator, can be persuaded by either the way a party is arguing and maybe by the judicial authorities that have been cited to interpret this clause in favor of a particular party. Remember, actually the biggest dispute doesn't come from the letter of the contract. Usually it is in the interpretation. Something in black and white could be saying this. But when you take into account something like industry practice, one can argue, whereas it is saying this is not what this contract means. It is deemed to mean A, B, C, D. So in trying to support their case, they'll of course be citing certain authorities, cases which usually are actual court cases. Then there is of course the issue of compromise conundrum. Now, in literally all the contracts that I'm familiar with, starting with, of course, the JBCC, going to the various FIDIC contracts, yeah, that my predecessor has spoken about, you realize that once a dispute arises, the parties are first obliged, in fact, it's contractual, that they must make an attempt to resolve the dispute amicably. They must make that attempt. And it's actually contractual, it's a contractual requirement. And only when that attempt fails, should they proceed to the next level. For example, in most engineering contracts, you find that once a dispute arises, parties are required to try and resolve it amicably through, with or without a third party. And if they don't agree, now they go to the first level, which is adjudication, where you have an adjudicator who will make a decision that will be only temporary binding. Because should one of the parties not agree with the decision of the adjudicator, then they can actually give notice to proceed to arbitration. So you can see that decision is temporary. It is not binding. Parties can demonstrate that they have tried to amicably resolve a dispute and it has not worked. They go straight to arbitration. There are some which say if you don't agree, you go to mediation, you go to education, you do this. It depends on the specific contract. Therefore, what I'm saying is that this compromise conundrum, sometimes you find that when parties have a dispute, they actually look at the quantum or substance. And depending on who is claiming, you may ask yourself whether it is worth pursuing in a particular way. If, for example, there is a claim for, say, 100 million, and in this particular claim, you find that the employer, for example, if the contractor is claiming, can say, look, you are claiming 100, but I can't pay you 100, but this 50, you see from the computation they do, we acknowledge that you owe you 50M. You see the difference between them now will be this other 50. And depending on how they manage their relationships. And you know, these relationships, actually the biggest player in helping both the contractor and the employer to manage their relationships before they go into full-blown dispute should be the consultants. And this is why we are saying that the consultants must actually develop this professionalism of not telling employers what they would like to hear so that they can probably earn a little bit more fees. But they should be telling the employers the correct contractual position. In many instances, I have told an employer, look, I've looked at this contractor's claim. I know it is like this, but having looked at it thoroughly, I think I would advise you to compromise or to accept up to this extent, because if we don't, even if the matter goes to arbitration, there are minimal chances that we can win this case. And you see, at that time, we shall already have spent money on the arbitrator and this and this. And you know, once an arbitrator makes an award, and the parties go for enforcement, at that time, hakuna urafiki. You see, the figure will already have been determined on the basis of the case that was presented by the contractor. You find something like now, things like that you could have negotiated earlier, things like interest that accrued before the claim came, Yeah, now you have no room to negotiate those because you let the arbitrator do that for you once you presented your pleadings. Then, of course, you know, from the award onwards, if you don't pay, there is an interest that will be accruing from the time that now the award is made to the time that you pay. Then, of course, there is a cost of the and you know, there is this principle which says that the cost follow the award. So if you lose, you'll also be bearing the cost of that. That is why before parties agree to delve into full-blown, say, disputes, particularly arbitration, they must look at the implication and decide whether is it not better to sit down and probably like Professor Mutuma is saying, in an effort for amicable settlement, there's absolutely nothing wrong with agreeing. Look, our difference is only 25 million. What is a give and take? Yeah, you forgot 12, I pay you 12. So you set it out. So the factor that was agreed, and then the difference is 50. This 50 you split 50-50. I find absolutely nothing wrong with that happening. But remember, that window can only become applicable before you go to full-blown, say, dispute resolution, like arbitration. Now, I think the moderator had asked me about, is it the third question about the informal?
US, just before you go,
Yes.
Moderator, allow me just to make a conversation out of this.
Yes.
Actually, last part, you hardly get a panel like this. The QS, I had a dispute, and
Yes.
he was very, very key. He was sitting as the third party neutral. And what he was saying actually translated very well in that specific dispute. I was coming from the side of the employer. There was a contract, I think you remember QS Bashir, and
Yes.
all of the issues that one you have mentioned that could be handled before that matter went to arbitration were actually resolved at that stage, where you now acting as a third party neutral could push parties to agree on what essentially they would not have the opportunity once that dispute now took off and it was within arbitration. So, moderator, you sometimes get live case studies where you'd have on your panel people that were speaking and in experiencing the very things that we are talking about. So it's not a theory, it's actually lived reality. So QS, you saved me a lot of money and a lot of problems. This is
Very fine.
one of your many.
But you see, moderator, what you're saying is that in forums like this, I think it is good when the resource persons, you see, talk from their experience. It's not a question of what you've read in books, because everybody can actually read a book and understand particular way. It is actually the application, the knowledge that we have, that we hope now to disseminate in a forum like this, so that if you have a challenge, you can say, I remember what Architect Kebabi said in this. Of course, people even consult once in a while. I do get, say, calls from people, maybe we're in a dispute resolution somewhere, and they would ask, if it were you, what would you say? How would you look at this? So it's normal. That's what I'm saying. I'd like us to take a very, very practical approach. Now, which is the specific question that you had asked me? Maybe I got excited about what Professor had said, but tell me my question. I have question number 1, 2, and 3. I'll not take a lot of time to definitely comment.
We are mostly touching on 3. It sounds relevant to what you're talking about.
Yes. You see now, this is, you see, we are calling about the informal. To me, what this thing you are calling informal approaches sometimes used to resolve, it's actually negotiations. These are actually another word for informal way. Is actually pre-arbitration negotiations, which, like we are saying, can be with or without a third party neutral. Yeah. And in many instances, I realized when consultants become objective, particularly the engineer or the architect or the QS for that matter, when they actually remain objective, they can preempt a lot of these disputes and save their clients a lot of money. So to me, what you are calling informal is actually, I encourage it a lot. Why don't you see whether you can resolve it out of this? There is absolutely nothing wrong with that. It's an attempt. However, what happens is that some parties can take advantage of this informal approach of trying to resolve a dispute. You see, they can use it as a dilatory tactic, where they are delaying. One party thinks they will agree. For example, an employer owes, and I have a case, but for obvious reasons, I cannot talk about the particular party, where, say, for example, arbitrator went to arbitration, but now the contractor, the employer, who is the respondent, has sought, say, a stay of the proceeding, arbitral proceeding, so that they can agree. They can go actually agree with the contractor and hopefully enter into what I call an agreed settlement, which will come and record as a consent award. But you see, that has gone on and on and on and on until now. The contractor is saying, no, but arbitrator, these are dilatory tactics. It's now 4 months down the line. Since you gave us this, we have not reached anything. So we would like now, we abandon that process and go back. You can see that kind of negotiation was an informal way of trying to resolve dispute. But so long as there is good faith from the parties, there is absolutely nothing wrong with using that. In fact, it can actually hasten instead of actually undermining or delaying, the time for resolving disputes. It can actually hasten, because you find sometimes disputes can be very, very protracted. Can you allow me to go to my first question?
You can. If I can just give a brief remark, I think the informality was assuming the lack of documentation and the fact that, not a fact, the assumption that this may not yield results, but like you're saying, a negotiation can be successful. And
Okay.
good faith must prevail.
Yeah, but let me say anything.
Yeah.
Any attempts to resolve a dispute without information is an exercise in futility.
That's true.
Remember,
She said.
Information is very, very important. Information is power. Remember, you have a contract, and it is on the basis of this contract that a dispute has arisen. So, at all you hope to prosecute a case that makes sense, you must have information. Your tool, your weapon is the information you have. Then the other party must also have information to counter your claim. So information is everything. So any attempt to do what we are doing in form without documents, I would say, without fear of contradiction, would actually be a waste of time, because what would be the basis of this negotiation? Now, coming to my first question, which is asking, from my experience, are Kenyan contractors and clients? And here, clients, I'd like you to put in bracket, consultants. Clients, remember what I told you, that clients hardly participate directly in the management of the project. They do it through their agents. Are they sufficiently transparent and proactive in sharing project data to support or refute claims for time and cost overruns? Very good question and very interesting question. I think in the first instance, I would actually say that they are not sufficient, they are not transparent, and they are not proactive. It's a very simple reason. If you look at a contractor and the employer, they have two different objectives. You see, the contractor's key objective as possible. On the other hand, the employer's objective is to get as much work done by the contractor for as little as possible. So you'll find that whenever there is a dispute, people pull surprises and people are trying to advance a case and give information that is supporting their case while concealing other information. Yeah, I've seen people who have come before a tribunal and they are actually using certain information to try and argue their case. Then, after a short while, you find the other party pulls another letter saying, but it's interesting you are referring to this, but you are ignoring this letter that was written by so-and-so. So in the first instance, I would say that transparency usually is not there. But in where people, remember this thing I'm saying, good faith is very important. People should be transparent if they are serious. They should be transparent. Being proactive depends. Contractors are very proactive in putting forward claims because more often than not, and I don't know whether my fellow speakers will agree with me, most claims actually come from the contractor to the employer, hardly the other way around. Although occasionally you'll find claim from the employer to where the employer is the claimant. But in most instances, the claimants are actually the contractors. And the contractors are very proactive because you see, in fact, there is this tag that we put on contractors where we are saying they are claim conscious. In fact, from the time they sign the contract, other than focusing on executing the works, they are busy looking at the loopholes that the contract has and putting a star, knowing hapa QS amesahau to multiply. So we shall use this to make a claim, That is becoming the norm in this country. Of course, in other developed world, you find that contractors have a team whose role is every day, each and every minute, to be looking to the contract and looking for an opportunity to make a claim. So I would say they are not. But you see, now what happens is that when, say, things come to full-blown arbitration, the arbitrator should be able to expose those ones who appear to be, maybe they are saying something while ignoring certain obvious facts. Looking at, I'm stopping there because I'm hoping this is going to be interactive. Some of the things I am saying because I hope to hear comments from the participants. Now, these issues of question number 2, technology like BIM, and digital project management become more prevalent. Do you foresee those tools strengthening or complicating? Obviously, they strengthen. They are supposed to be your advantage. They strengthen. They should rather strengthen. But as to whether they actually do or don't, depends on how these tools are applied. You find that I'm not an expert on BIM, but I know these are technology that is intended to enhance efficiency in the industry. And if it's going to enhance efficiency, it means that even data, even the documentation of information should be easy with that particular BIM. But now, when you look at, say, for example, like the Kenyan case, you see the way we use BIM is actually at that collaborative level. You find that you do not, I've hardly seen a project where, say, BIM has been used right from the first step of designing to the end of the project. Then the same information has been used for management. This for property management. You'll find that whereas we use BIM in certain aspects, there's a very, very big human interface. So that is why I'm saying, yes, it's supposed to be helping. And in fact, with time goes, as we embrace BIM more and more, you find at the click of a button, you'll be able to see all the information that was provided. So I would encourage and I say, yes, it's a very good tool, that should be able to make it more efficient. I think
Thank you so very much, QS Cairo. I feel very educated now, and I am seeing areas where I can do better, both in the built environment and as a dispute resolver. Neutrality is very important. I'm picking that up and that time and evidence do vindicate a consultant. So the employer may not be too happy as you're giving them the truth, but eventually it will emerge and they'll be richer for it. The project will, in short. We're talking about time, and I think we are running out of it, but I'd feel very guilty if we went away without reading the sentiments that are coming in. Mark Oroko, I'll pick that as the first question for this session we're having now, Q&A. And he sends one to Kibathi and Kenneth Wayne. He's saying a brief scenario. The contractor claims the employer's design is defective. That's on the red book. A design change was made mid-project, leading to performance issues. Employer disputes a defect claim on a design prepared by the contractor, reference to the yellow/silver book. So his question is, who bears the risk of a defect in the original design? It's a four-part question, so I'll just read all of them at once, and then any panelist can chime in where they please. Under what conditions can the contractor claim relief for employer's design errors? What is the standard for fitness for purpose under the Yellow Book of 2017? How do value engineering proposals affect the design liability? And I think the risk has been mentioned. Who bears the risk of a defect in the original design has been asked by several people. So Kibathi, if you could go first.
Yes, I believe you can hear me, right?
Yes.
Very good. And Bana Cairo, you can see me as well.
I can now see you. I'm happy I can see you now.
No, the other time I think you probably missed because my picture was always there. Okay. But I think this question is really asking, in other words, who bears the responsibility for the design issues? The contractor claims that the employer design is defective. Now, obviously, the consultant would have a big responsibility here, even to assess where the dispute comes from, even from the red book. Is the defect which the contractor claims coming from the employer's design? In other words, did the employer input something which makes the design defective, so that maybe during the construction he has to deal with variations, some certain changes in his construction method, or even things that may increase the cost or not? And I think these are questions which often come, that the design which has been given by an employer, if that is the case, it has some defects. Perhaps he didn't look at the various options and and mainly there could be some items which were omitted and things of that kind. So the contractor, of course, sometimes would make claims if he finds that he can make some money. And as Mr. Bwana Cairo said, some contractors are very claim conscious, and they are looking always for opportunities to make claims. And because they know that sometimes you can make more money in the claims than from the actual work that is valued. Then design changes were made mid-project, leading to performance issues. Employer disputes a defect claim on a design prepared by the contractor. Obviously, even in the Yellow Book or the Silver Book, the contractor who makes designs must also be ready to admit if there are any problems, and also perhaps even to take responsibility. If the design changes are coming mid-project, it means that there must have been something which was omitted in the beginning. Probably there were not adequate interaction, and so on. And therefore, that can cause problems. And it is obviously necessary to consider all these options, each question, these issues, so that these kind of changes are not do not arise. I know that some of the questions you have put there is who bears the risk of defect in the original design. Obviously, it would be the person who made the original design. If they did not see that the design was itself having some defect, and nobody raised up that question, then of course it becomes an issue. And the person who makes the design would bear the responsibility. And then under what conditions can the contractor claim relief from the employer's design error? If the contractor really used only the contractor's, the employer's design, then of course it also means that if he had seen ways of dealing with those issues, maybe he omitted to bring them up. And obviously the person who designed and made the necessary design, of course, let me also say that these design issues by errors by the employer may also have been done by consultants who are acting on behalf of the employer. And therefore, it is necessary particularly for consultants, to be very careful in this kind of way. What is the standard for fitness for purpose under the Yellow Book? I will leave Bwana Kairu to answer that one. And how do value engineering proposals affect design liability? Usually when you are doing value engineering, you are looking at ways of making the project a little bit easier, either to handle or even cheaper, saving a little bit of money. And the proposals can affect the design and the liabilities if the new what you call value engineering in a way makes it more expensive. But obviously, because it is actually called value engineering, it is meaning that you must add value to the proposal. Otherwise, it doesn't really add any value, so to speak. And therefore, the liability, of course, would come to those who made the proposal to change, and also whether there was enough discussion with regards to what was being considered in the value engineering. Was it necessary? Is it effective? Is it really adding value? Is it making the building better? Or is it making the building cheaper and probably more efficient? Bwana Kairu, could you look at question number 3, the standard fitness of purpose under the Yellow Book 2017?
Okay, thank you. Thank you. I must say I may not be able to comment on that substantively because I've not looked at that particular clause for a while, but I'll come to it. But first, let me just recap what you've said, the question. Say, who bears the risk for original design? Okay, remember we said that this issue of risk allocation is actually to be found in the contract between the parties. And now when you are signing a contract, usually it is very, very clear with regard to the respective parties' rights and obligations. And when it comes to matters design, I think there is also a provision in most of the contracts, be they FIDIC, be they even the other standard form of billing contract. There is a provision for a contractor to be able to raise any issues with the design before they execute. One of the things we must remember is that, and I'll be very interested to hear what Professor Mutuma will say, a contractor is not a lay person. A contractor is assumed to have certain knowledge and skills. So if a design is obviously faulty, a contractor cannot proceed and actually execute it as is, while it is very, very clear that it will not function. I think in the first obligation, their first obligation would be to raise the issue with the designer, who will be the architect or the engineer, And you have had instances where, for example, say an engineer has designed a particular structural element, and the contractor says, from my experience, I think the reinforcement in this member is inadequate. We should blah, 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 blah. There is a conversation at that point, and you find, because the contractor is using his experience, maybe the engineer could be a rookie who is just using his books without realizing sometimes you can do things a bit differently. And you find in the event that the consultant is insistent that, yes, thank you for your information, but please, I hereby instruct you to proceed and execute it. At that point, the contractor becomes automatically absolved of any responsibility of that faulty design if they want to now proceed, do the work, and it failed. On the other hand, if say the contractor did not raise the issue, but they just went ahead and it failed, I think there'll be a very big debate, because you can't do something that you can see will obviously not perform just because it was specified. You are not a lay person. You are an expert. A contractor is an expert of sort in construction and from the experience. And that is why they are hired to be able to do work, because they've got certain experience. I know there are many legal issues that will arise out of this, but I personally believe that a contractor could be held liable for proceeding and executing work which are obviously not fit for purpose. And then they say, but you told me to do it. Yeah? They must first question, there must be evidence that they have raised that issue, but on the insistence of the consultants, they have done it. But there have been grave situations where, by the way, the consultants, the contractors, have refused to execute certain works because they believe that these works are faulty and they can even be dangerous. And they say, unless they are indemnified, they will not be able to do those works. There are certain instances that can happen because you cannot just go ahead and say, for example, cast a slab, which is under enforced, and you know it's just a matter of time before it starts sagging and then it collapses. You can't insist. The engineer told me to put this, the engineer who insisted. No, you can say, I'm sorry, I can't do this job. So these are actually difficult situations, but they do arise. I don't know what a professor would say about that from the legal perspective.
No, QS, I support you. Actually, that is the legal position. Unless the employer, for some reason, either through instructions, assumes liability, the contractor remains liable. In those contexts of value engineering, the employer is not liable for the very astute reasons that QS has shared. The expertise of the contractor in knowing what they are proposing as a value addition. That expertise, I think, if I go to some of the questions on the yellow and silver book, that expertise, I think, is what has informed the position when it comes to this fitness for purpose standards. So generally, there's a strict liability in those contexts, unless by implication that strict liability is ousted by either the nature of relationships between the contracting parties. But the standard is, of course, strict, and in certain cases, it can only be ousted if they actually demonstrate the exercise of what you call reasonable care. But the typical standard is that of strict liability. Then on the first two questions around what our colleague, I think they demonstrated that they know something about the allocation of risks when you're looking at the different books, the red book, the silver book, and so forth. So the allocation of risk follows who is responsible for different facets. So in the red book, 2017, you'll see the employer is tied to design. So any risk around the defects, because the employer provides the design, will now sit with the employer. And of course, there are provisions on how the contractor then can raise a claim for that design defective nature. In the yellow book, of course, it has shifted. The contractor is the one that is responsible for design. And in the same way, then the risk also shifts for any defects in terms of that design. And then I think all of that will then flow around the reliefs that now either party can claim from the other. And that's why the standard contracts are very useful, because they start with who is responsible. They allocate risks like we just basically spoke about in the Red Book, and all the other subsequent claims, including an extension of time claim. The cost claim then follows that allocation. It shifts, as you've seen, between the Red Book and the Yellow Book. So that's my comment. QS, we are reading from the same page in that one.
In so answering, you have addressed a number of questions that have come up, risk apportionment. And sticking with the law, Prof. Sharon asked, if you could please comment on the Construction Payments Adjudication Bill of 2025, particularly the bill's focus on contractors with no clear remedies for purchasers.
Specifically, sorry, I didn't hear the last part.
Particularly, the bill's focus on contractors with no clear remedies for purchasers.
Mm-hmm. Yeah, I think I could go on, but we have done, I think, a paper together with AAK on representations in this bill. There are many provisions. One is weaknesses that we've identified, including the one, Sharon, that you raise. And that what we're trying to do, I think what the bill is trying to do is to sort of model what we see in other jurisdictions, including Australia, Singapore, to cure the problem of payment. As you know, adjudication has a pay first and then argue later policy. But in our jurisdiction, it doesn't, that is not backed or supported by statute. So when we look at the construction adjudication bill, there were 3 areas that we had raised. One, when we looked at section, the early sections 1, 2, around there, and 3, we felt that my interaction with AK, that it should be expanded to not just deal with payment disputes, but to deal with the entirety of construction disputes. So that's one, because you'll see section 2 says that this is specifically dealing with construction payments. The second issue tying to that is somewhere in one of the middle of the sections. I can't remember which one. But it doesn't have guidelines on the resolution of those construction disputes. I think that section sort of dealt with that only when there is a consent of the parties to an adjudication, then that's when the adjudicator then can determine a series of disputes. And as you know, this is one very common feature with the subcontracting system, that you will have various layers of disputes. In fact, some spilling over between the employer, the main contractor, domestic contractors, nominated subcontractors, sort of domestic subcontractors, and so forth. So we have made a proposal with AK that all of those layers should then be, the adjudicator should be allowed to sort of consolidate that, instead of having separate as it were, avenues, which makes the first reason why you have adjudication and these mechanisms is to reduce costs. So if you don't allow that kind of consolidation, then you have increased costs. And then I think there is one of the major areas, Sharon, that we don't feel appropriate in reference to the bill is, again, this appeal to the High Court, because it takes the decision and allows for a party to sort of, it doesn't give the finality that we want, that the finality that you get in arbitration, but it allows an aggrieved party to then giving and taking much more with the other hand than was originally anticipated. You end up now back again into the litigation, mlolongo. And so I think there should be either a way where that, like most contracts do, from adjudication, you have an arbitral tribunal just sit, not necessarily always on the merits, and that allows for expedition. The last, I think, touches what a lot of our members have been saying in AK, that you'll see there's something that they've set up. This bill sits alongside with other bills. There's something they call the Dispute Resolution, National Dispute Resolution Council. And that council is meant to have a kind of representatives drawn from different sectors. We have been saying that they have only provided one slot under the name of AK, not recognizing that AK has several disciplines, and that is very disproportionate to where these disputes come from in terms of percentage, and how much should be allocated to the built environment. Two, I think you'll see the chair of that council has to be an advocate. So that by itself, again, suggests that these disputes are more or less construed in the adversarial systems that the field of law has set up, but that's very different from ADR. And we are asking why that limitation of having the chair as an advocate of a particular year's standing equivalent to a judge of the High Court should actually be there. I hope that sort of sums up where the built environment has issues with that bill. Thank you very much, Sharon.
It absolutely sums it up and makes for good reading. Chartered Institute has put some resources. I suggest we go through them and find other similar materials to be well versed with what's happening in our sector right now. And now I'd like to take last three questions. In fact, I think I'll combine two, as we give the panelists a chance to give us one last, to give us their parting thought. Sorry, I'm losing the question. Makoroka said, thank you for your kind remarks. CIArb is hosting this talk. Oh, sorry, that's a response from the Institute, where Mark had said that these discussions and conversations are quite insightful and timely. It's my wish that the organizers can plan for more of such. The panelists are top-notch aficionados, and I agree with him. And now that we have your ear and no fee note, somebody else has asked for advice on an issue they are going through. Kindly, our seniors, help us here. Robert says, I'd like your advice on a conflict involving a design and build interior fit-out project. In this case, a contractor entered into a design and build agreement with a client. The client accepted the contractor's interior fit-out design proposal and agreed to fully finance the project. They also agreed on a payment schedule, 50% upfront upon engagement, 30% upon achieving 50% of the work, and 20% upon completion. The client made 50% upfront payment. The contractor began the work. Later, the contractor believed that he reached 50% completion and requested the second payment of 30%. However, the client disagreed and stated that the work had not reached 50%. The disagreement escalated when the client brought in a QS after the work had already commenced. The QS assessed the work and agreed the original rates were exaggerated, using lower rates to determine progress. The contractor did not agree with this revised evaluation, and as a result, the project stalled. There is no formal contract signed, only the proposal and initial payment. How should a dispute be handled, and what would be the appropriate professional or legal basis for resolving it? QS Kibati, could you please answer that one for us? Sorry, Ak, my apologies. Then Samuel has a question that I would like to send QS's way. Does an extension of time automatically warrant a claim for disruption losses by the contractor? Yeah, I have a question for Prof. Lucky, but then let's first hear those two, along with your parting shots, and then a question for Prof.
Thank you very much. I think, first of all, let me say the person who, I forget the name you said, who asked that long question. It is Robert. So detailed. Robert, as an arbitrator, I would be asking for appointment as well. As well as submissions from both parties.
Yes.
And be paid a little bit of it in advance. Let me say that, first of all, obviously the question is rather longish, and the one cannot quite absorb all the issues. But obviously, it points to the fact that when people are making an agreement between them, they should really look at all the details of what is expected by the other party and what is expected of them. What are the expectations? What am I supposed to do? When? How am I going to be paid? And is the payment schedule agreeable to me? Because you can't run at the middle of the project and say, oh, I think you should pay me half if you had not agreed. If the work was to be assessed at all stages in the usual manner, and the payment was to be based on a certain level of construction, even if it's a design and build, then of course one has to wait until that time comes. But if a contractor who is doing the work wishes now to be paid a little bit of the money in a different manner, then he should be making an application and make sure that the employer agrees to it. And hopefully this can be agreed long before the work starts so that there is no problem. I must say the question is rather lengthy and of course quite involving, and without also knowing every aspect of the issues pertaining to this particular dispute, one would hesitate to say that you can do this. There is no solution which fits all. One has to look at each particular matter, look at the issues, look at the contract, what was agreed, because basically that is the basis of any resolution of any dispute. So, and of course, well, I hope the person, Robert, was not expecting to get a solution here and say that I had in the webinar that I should do this and the other. That cannot be the case. So really, you have to look for professional advice And maybe you can consult somebody who can give better, more informed advice. Thank you.
And I believe Robert is better directed now. He'll pick up the conversation from there.
But maybe moderator, just on the same questions, I think we shall just use it to underpin certain principles. Robert has given a very good, a very big narrative, like of course Architect Kibade has said, but this forum does not have the benefit of hearing what the other party is saying. But obviously there is a potential dispute here. And this potential dispute, remember what we said, that all good contracts should have a provision for an effort for amicable settlement in a dispute before they go to a full-blown, say, arbitration. First and foremost, I don't know, I doubt that this particular agreement between Robert and the contractor, design and build, has a dispute resolution. Does the aggrieved party go to court or go to arbitration? Because remember, the arbitration clause in a contract in itself is another contract. But it is possible that in this particular contract with Robert, there is no arbitration clause. But obviously here there is a QS who was not there first, coming in later. And now, like Kibade is saying, we are saying this without prejudice. And Robert should be very cautious not to use this information as his professional advice. But remember, again, like Architect Kibade said, if this dispute was to be resolved, say through ADR, remember that the person who is solving this problem, first, the parties can agree. Let us go. We don't have a dispute resolution clause, but can we agree that now that we are differing, we appoint an arbitrator? You know, under this thing we call freedom of contract, parties can agree, mutually agree to vary a contract and say, bring in that clause if it is not there. And probably maybe that's what they can consider doing. Otherwise, one party cannot unilaterally decide to introduce something which was not in the original clause. It has to be mutually agreed. So this is why we are saying we have to be a bit careful. And now you see also here that other than the terms, there was no contract written. Those terms are the contract. It's only that it was a very sketchy contract that left out very critical issues that should not be missing in a contract like that. They just focused on this and the money. So there is a contract, and the contract are actually those terms that they agreed. But it looks like the terms were not adequate to manage a contract like this. So it is going to be a very, very complex issue. And again, this is where I was saying, sometimes you look at what is it that this contractor, design and build contractor, and employer are fighting over. What is the quantum of the dispute? Yeah. So depending, if the quantum, say for example, is something that is relatively small, they are better off advised to try and resolve it amicably through what you are calling informal. Remember this informal way of trying to agree on a dispute, as opposed to going through a full-blown. I know they'll bring in lawyers, and I'm saying this with all due respect to my good friend, Professor Mutuma. Lawyers, once they are brought in, you know, the lawyers see a problem everywhere. And obviously there has to be some money for opening the file, then they do this. A very small issue in a building contract can be very protracted if you bring in lawyers who bring all sorts of legal technicalities. And knowing that really these are not legal issues, they are just business issues. You did work and are supposed to pay you. You didn't what you agreed. So basically, I think there are many ways to look at it. And I think this is a lesson to the people who are here in this forum, that be aware that you'll actually be bound by the contract that you sign, even if it is a one-word contract. And you see, what normally told is that while you are in good terms with that person, because when you're a contractor, you need a job, and there is an employer who wants to give you a job, at that point you are buddies. it is at that point that you should say, hi, listen, my friend, let us agree now. Should a dispute arise, how do we solve it? Or in fact, you can even say, in the unlikely event that a dispute arises, what should we do? If you ignore that, remember when a dispute arises after, you'll hardly agree on anything. You'll be fighting. Egos, tempers are high. So you may as well, at that time when you're negotiating, ask yourself, and if you want to say, in the unlikely event we don't agree, how do you intend that we solve this issue? Discuss it, put it in your contract. Thank you.
Thank you so much. Thank you so very much. I don't know, we're severely out of time. I don't know, before we assist by AK, I think the next question, I'll just highlight it, and if we can get an abridged version from Pro. Is it allowed? Okay, they've allowed us like 2 more minutes. So, Dr. Raphael asks, AI is an emerging global tool in the construction industry and in other sectors in our economy. The reality is that this tool has come to live with us in our routine life. How can we therefore employ AI to predict and manage conflicts before they degenerate into full-blown disputes? This question is generated from an MSc thesis from one of the students.
I thought you were going to say, Madam Moderator, it is generated by AI.
Missed an opportunity there.
Yeah, thank you very much, Daktari. I think AI, like everything else, is revolutionizing all industries, including the built environment and projects, and also the dispute resolution space. From the built environment, particularly with standing DABs, dispute adjudication boards, it has started to be incorporated as in terms of early warning systems to, in advance, give an indication for various reasons where projects are starting to go off the rail. And because you just feed it with data, and it sort of warns you along, using the data, the critical path, and so forth. There's a call that keeps coming in. I'm trying to disconnect it. The other thing I think of importance is in the dispute resolution space. There's so much that has been said about that and AI, because I think the latest thinking is whether one day, AI will replace the arbitrator, the adjudicator, and that development starts with how it is encroaching different spaces. It's able to collate, categorize, analyze documents, and even write the dispute resolution, whether it's a decision or an award. That discussion also has another layer of its dangers. Everyone knows from ethics, integrity, hallucination. There is what they call the AI it just goes off and tells a story as though it was real, but it is very, very false. And I know Daktari Mwalimu has seen that, even with his essays, I'm sure, and with Studio, as people present, it's very unlike when we were, Daktari, we were in the world of drawing boards, T-squares, and so forth. So today it's very different. It's all electronic. Then in terms of, there was somebody who asked about an extension of time and whether the extension of time automatically leads to some entitlement for loss and monetary compensation. And the short answer to that was no, because while it follows the books, depending on which book you're looking at, the FIDIC sample contracts. In certain cases, it will entitle you to more time, but not automatically to cost reimbursements. And when you want to prove that, you have to then very specifically provide the evidence for that disruption of loss, whether it's productivity and overheads, those material on-site equipment. And that is where we find a lot of cases collapse. I think QS and Architect Kibathi, you'll see in your experience, you've seen so many of those things where it clearly the contractor has that claim, but you start now asking, show us what equipment was there, and they have not kept the record. Show us the laborers, show us the period that this equipment was engaged and for how long, but they don't have those records. So I just wanted to say that that question of evidence and records, manpower charts, data on progress and whatever stage of construction was, and most importantly, the impact financially. The models that have been used, the QSs are really at the heart of this. What models have you used to calculate financial impact? That is where most of those claims collapse. It's sometimes very sad, like what QS Cairo Basha is saying. You cannot rewrite contract. You cannot, when you're sitting as a third-party neutral, prosecute a case for somebody. You can only watch in at level of compassion. In fact, sometimes when you retire, you feel, oh dear, I know this work was done because the product is there, but there is no proof on what it cost and so forth. Asante sana. Back to you, moderator.
Asante sana. We have learned so much this afternoon. Unfortunately, we are severely out of time, but it's not loss, it's all gain. Thank you so very much to our panelists for finding the time to talk to us today. They say if ever I've seen fight because I've stood on the shoulders of giants. So thank you to the giants of industry. We really appreciate your time. To our attendees, thank you so very much for finding time. We'd have no discussion, we'd just have a conversation of 4 people, but because you're here with us, we've been able to have a successful webinar. And now I see that our hosts are online and ready to take the platform and call us to action. Thank you so much. It has been a pleasure.
Yeah.
Thank you.
Sorry,
So
if you allow.
good evening, everyone. I
Just
hope
to say
I am
that,
audible.
just to say that I see before our CEO says I did not do justice to something. There is a very unique course, Introduction to Arbitration and ADR, just for AK members at discounted rates, and it is on 4th and 5th of September. So we want to make sure that when QS Cairo and Architect Kibathi retire, that they will not go as libraries of experience with all of this. So you'll see there is that course on 4th and 5th of September, and we really encourage you to join. We are very, very intent on making sure a lot of the younger members join. In fact, I was so happy. If he had a chance, he would have spoken. One of our key young members group leaders, Mark, I can see Mark was here. I think he was, I heard you mention his name. So they are very intentional on making sure that more and more young members are there. And so Mark, maybe you can share your contact just to make sure that you get as many young members. I've always been there at ADD trying to get more and more of the architects and the built environment professionals. If you could share and help to get more traffic as dispute resolvers from that side. Asante.
All right.
Thank you,
very
Prof.
much.
Thank you.
Okay. I don't know whether I'm audible. So I think I'll quickly introduce myself. My name is Martin Bogwa, the Secretary of the Construction Project Managers Chapter, the joint organizers of this very successful webinar that we've had today. I'm a member of the Governing Council of AAK and also a member of the Chartered Institute of Arbitrators. And I would like to take this opportunity first to thank our eminent panel of speakers. I think from my guesstimation, yeah, we'll call it that, we had close to more than 100 years of experience on our panel. So I think it was a great session where we learned a lot. And especially those who are new in the ADR field, this was an apt time and session for you to take up some learning. Secondly, I'd wish to thank our moderator, Architect Bridget Manza, for running this session as smoothly as possible. She tried as much as possible to get and extract the wealth from our panelists, and I'm sure all those who attended the webinar have taken home something to learn from what our seniors have given us today. I would also wish to take this opportunity also to appreciate the board members of Chartered Institute of Arbitrators who were present today, starting with our speaker and who is the chair of the board, Professor Kenneth Wayne. Special mention to the African trustee, Dr. Chikwendu Madumere, and all those other board members who are there today with us. I also saw some council members from the young members group of the Chartered Institute of Arbitrators. Thank you very much for gracing our occasion. Next, I would wish to thank fellow members of the Governing Council of AAK. I saw on the meeting there was attendance from the Honorary Treasurer, QS Diana Musiok. There was also attendance from our past Honorary Treasurer, QS Patience Namilondo. Thank you very much. And any other chapter council members from other chapters who attended the session, thank you very much for supporting the Construction Project Managers chapter. I would also wish to thank my fellow chapter council members from the Construction Project Managers chapter for assisting in organizing this webinar. Your efforts have not gone unnoted. All this would not have been possible without the assistance of the secretariats, the joint secretariats from AAK and CIArb. Thank you very much to those who have been pushing the information to our social media pages and those who have been contacting members to join us. Thank you very much to the both secretariats. And finally, last but not least, this would not have happened without our participants. The last check QS Cairo had done was at 148, and I can confirm it almost got to 200. We were at some point at 198 members. So it was almost like you're addressing a political rally. Thank you very much to all our participants. We hope that you all learned something, and without you, this would not have been possible. And finally, now a call to action. The reason we held this webinar is that we've been receiving a lot of queries from mostly the AAK membership as to how they can join the ADR field. And probably to highlight, because our speakers were very technical today, probably for someone who has never been involved in any ADR work. ADR is alternative dispute resolutions, and majority of the construction work is dealt with either through negotiation, construction adjudication, or arbitration, which are the most common ADR mechanisms we use in the built environment. And the Chartered Institute of Arbitrators works as a trainer and also as a panel of role of neutrals for those who wish to practice in those fields. And that is why we felt as AAK it was necessary to form a partnership so that those who would wish to get onto the ADR bandwagon can use this opportunity to hear from the experts as to what it takes, and then go a step further and undertake training. And as has been mentioned by CIArb Chair, Professor Ken, we have designed and we have planned for a purpose-made introduction to arbitration training, specifically for members of the built environment, that will be held on the 4th and 5th of September, jointly organized by CIArb and AAK. And we will be releasing the registration link for that. And I'm hoping out of all the 198 members who are logging in today, those who are not part of the ADR practitioners will take this opportunity to get onto the field by having specialized training, so that as we do our primary professions, as we undertake our roles, we may be able to increase our knowledge when it comes to contract management, dispute avoidance, and dispute resolution whenever they occur. Because as has been mentioned by our seniors, sometimes we try our best to avoid disputes, but they end up falling on our laps. So this training is very important and critical to ensuring that you handle all these matters appropriately. So I'm sure AK, the Secretariat at AK and the Chartered Institute of Arbitrators is going to release more information as to that training to be held on the 4th and 5th, but we hope that everyone here is going to be onboarded onto the ADR practitioners list. So it's now 4:30. We have run about 30 minutes late. I think it was a worthwhile extension of time. I've seen a lot of questions about extension of time. I'm hoping we won't get any claims from our speakers. Thank you very much for your time, and thank you very much to those who attended this session. This session was started off by CEO, Chartered Institute of Arbitrators, and I would like to hand it over back to her for her to give her closing remarks and close this session. Thank you very much.
Right. Thank you, Martin, and thank you to our very able panelists. The vote of thanks has already been moved. Mine is to just say that the recording of this webinar will be available on the YouTube of the Chartered Institute of Arbitrators, and we're going to inform the Secretariat then on the AAK side once it has been uploaded. I've also put on the chat function the link to the application form of the referenced introduction to arbitration and ADR that is, as Martin has indicated, that this is going to be a continuous engagement, and we'll get more view coming on to the other side of dispute resolution, not only just to be tribunals, but also to get more information about arbitration as well as ADR. I'd also like to point out that from the 17th to the 21st of November, we shall be running the CIArb ADR week. But when you hear CIArb, it's not just about CIArb, but essentially it's a stakeholders engagement on arbitration. We have a day on arbitration, we have a day on mediation, we have a day on construction, adjudication, and infrastructure disputes. We have a day on mediation and AJSs. So this is going to take place, as I mentioned, from the 17th to the 21st of November at the Kenya School of Government. And we are inviting all major stakeholders, because we'll be having such similar conversation on where arbitration ADR meets the stakeholders, where it meets people within the built environment. So there's a specific day that we've already put aside for conversation strictly on construction adjudication in the construction sector. So we are inviting all of you to participate, and we'll be sharing that information with our partners through AK and others. And in addition to that, someone mentioned in the chat function about the constant need to have this conversation. And I'd like to take this opportunity to assure you that we have had some of these concerns or some of this feedback, and we've taken it in stride. And this is to confirm that as the Institute, we're trying as much as possible to have this conversation at the very least twice every month. And in others, we're having them on a weekly basis. So reach out to us if you have a critical area that you'd like us to tackle. We'll find a way of incorporating within our already existing calendar. And as you can see, we have the wealth of experience. We have very competent members who will be able to champion such conversations. Thank you so much for your time. Thank you so much for your participation. I'd also like to acknowledge that we had been joined by our vice chairman, who was also on the call, as well as some members from our sister branches in Zambia. So thank you so much, and we wish you the very best as you get into the rest of your week. And any questions, let me actually put our contact details. Any question following this webinar, and maybe if you feel like there was a question that you had that was not fully, that was not, either you did not get a platform to get it answered, or that was not addressed, that was on the chat, just text it to the info@ciarbkenya.org, and we'll pass it on to the panelists to ensure that you get an elaborate response to it. We remain at your service, and we continue engaging in these collaborations to ensure that we are constantly creating value, and we are constantly bringing the information that you need to provide solutions within your respective areas of influence. So that marks the end of this webinar, and we really thank you for your time and look forward to engaging with you on the next one. The next one will be on 30th of July, and we'll be talking about AJSs and access to justice. Thank you very much, and have a great weekend. Asante.
Asante.
Thank you.
Thank you. Bye.
Asante.